Good evening, and welcome to a conversation with Associate Justice Ruth Bader Ginsburg of the Supreme Court of the United States. Many thanks to Duke Law School and Duke DC for co-sponsoring this event. My name is Neil Siegel. I am a Duke graduate, a former law clerk of Justice Ginsburg, and currently the David W. Eichel Professor of Law and Professor of Political Science at Duke Law School. I hope one day to attend law school myself. I am also the director of the law school's DC Summer Institute on Law and Policy. The institute enables students who are diverse along many dimensions and who are thinking about law school the opportunity to try it before they buy it by taking short introductory law school courses taught by Duke Law faculty each summer in our nation's capital. This summer, we are honored that Senator Mike Lee of Utah, as well as Ms. Danielle Gray, former senior advisor to U.S. President Barack Obama, have joined our teaching faculty. The Institute is in its 6th year. Over the past 4 summers, we have been hosted in very fine fashion by Jones Day, one of our nation's most prominent law firms. Thank you once again for your hospitality, Jones Day. For the 6th year in a row now, Justice Ginsburg is giving generously of her time and her mind by joining us for a conversation about law and life. She became a judge on the U.S. Court of Appeals for the D.C. Circuit in 1980 and a justice on the Supreme Court in 1993. She has served on the Supreme Court for a quarter century now, and judging from her push-up regimen, she is not done. Justice Ginsburg is one of a small number of justices who earned a prominent place in history before ever becoming a judge. She did so by persuading those in positions of power to honor a truth that ought to have been self-evident, but historically has not been, that women and girls too are part of the people in whose name the Constitution purports to speak. Her work as a justice, including in recent years when she has written some of the most important opinions of her storied career, has reflected her commitment to the equal citizenship stature of all people, including people who traditionally did not count or count nearly enough in constituting we the people. The Justice will now offer us a talk on key decisions of the 2017 term, after which she will join me for a chat. Justice, welcome, and thank you once again for making this evening possible.
Thank you. I'd like to start by acknowledging the presence of my favorite client, Stephen Weisenfeld, and his wife, Elaine. The term just ended was momentous. Our docket included far more than the usual number of high-profile disputes. But topping the headline news, at our closing conference, Justice Kennedy announced his retirement effective today. Counting his years as a judge of the U.S. Court of Appeals for the Ninth Circuit, he has served on the federal judiciary for 43 years. I will miss the pleasure of his company at our conference table, his helpful suggestions on circulating opinions, his recommendations of art exhibitions to visit with my chamber staff, and much more. The biggest procedural news of the term, the court finally adopted electronic filing. Most federal courts began accepting online submissions more than a decade ago, but the court until recently remained wedded to paper filings. Beginning last November, however, all parties represented by counsel must submit electronic versions of briefs and petitions through the court's online system, in addition to lodging paper copies. Most documents submitted electronically are made available instantly to the public on the court's website, free of charge. Pro se litigants continued to submit documents on paper, but the court staff swiftly converts those into electronic form. As in prior terms, we heard from some keen observers of our oral argument sessions. According to our court watch's reckoning, Justice Breyer spoke the most words, 22% of all words spoken by justices during the term. Justice Sotomayor came in second at 17%, while Justice Kennedy trailed with 5% of total words, not counting Justice Thomas, who asked no questions because he thinks the rest of us ask far too many. The award for most questions asked in a single case went to Justice Alito, who posed an impressive 44 questions in Minnesota Voters Alliance v. Mansky, a case involving proper attire in voting venues. And Justice Kagan took top honors for asking the longest questions, averaging 93 words per query. The court released 59 signed decisions in argued cases last term, dividing 5-4 or 5-3 in 20 of the 59. We were unanimous, at least in the bottom line judgment, in 28 out of 59, or 39% of all opinions. Our sharp disagreement rate, 34% of all signed opinions, was considerably higher than in prior terms. The preceding term, for example, we divided 5-4 or 5-3 in only 15% of all decisions rendered. In addition to our 59 signed decisions this past term, we issued 12 per curiam decisions, 11 of them opinions rendered without full briefing or oral argument, just on the basis of the petition for review and the brief in opposition. Add to those numbers one judgment in a water access dispute between Wyoming and Montana on our original jurisdiction docket. Do you know that the court is the first and last instance when two states have a dispute, and it's mainly about water rights? So our total decisions rendered during the term came to 72. Now let me turn to some of the high-profile cases. Among cases generating the largest public interest, Masterpiece Cake Shop against Colorado Civil Rights Commission. That case involved a baker who refused to sell a wedding cake to a same-sex couple because same-sex marriage offended the baker's sincerely held religious belief. The baker had been sanctioned by the state's Civil Rights Commission for violating Colorado's anti-discrimination law, which prohibits business enterprises from refusing to serve customers on the basis of enumerated characteristics, including sexual orientation. Writing for 7 justices in full or in part, Justice Kennedy reversed the Colorado Supreme Court, which had upheld the Civil Rights Commission's decision. The majority held that the commission violated the baker's free exercise rights by exhibiting hostility to his religious beliefs, by treating his case differently from the case of bakers who refused to make cakes condemning same-sex marriage. The court also observed that 2 of the 5 Civil Rights Commission members had made comments suggesting the baker's religious faith was not a legitimate reason to refuse to serve the gay couple. I dissented, joined by Justice Sotomayor. I challenged the majority's equation of the 2 service refusals. It compared 1 was motivated by objections to a protected characteristics. The other was driven by objections to producing for any customer cakes bearing demeaning messages. It's one thing to say, I'll sell to one group of people, heterosexual couples, and not another, same sex. And quite another to say, I will not make a cake with a demeaning message for anyone. It is a product that is simply not on sale in my shop. Only two of the many decision makers in the case I added, the two commissioners on the Colorado Civil Rights Commission, only two made comments that might be interpreted as expressing hostility to religion. Two commissioners, but the case then went through 2 levels of court review, and no one charged that the Colorado courts harbored any religion-based bias. One noteworthy case from the Second Circuit escaped our judgment, United States against Microsoft. It concerned a federal law enforcer's demand that a US-based email services provider disclose the contents of emails stored abroad in Dublin, Ireland. The question presented, was the demand an unauthorized extraterritorial application of the Stored Communications Act? The Second Circuit had answered yes, reversing the district court's judgment. Less than a month after we heard argument, enough time for a swift opinion writer to have a draft in circulation, Congress resolved the case for us. It amended the Stored Communications Act to clarify that, yes, law enforcement officers generally may require companies like Microsoft to disclose emails stored abroad but accessible in the United States by pushing a button. Both Microsoft and the government supported the amendment. With no live dispute remaining between the parties, we dismissed the case as moot and vacated the judgments of the Second Circuit and the District Court so they would have no force as precedent. We might have had an inkling that that would happen because a number of senators attended the oral argument in that case. Another closely watched case brought good news for risk takers and less welcome news for the Las Vegas sports book. In Murphy against NCAA, the court considered the constitutionality of the Professional and Amateur Sports Protection Act, or PASPA, a 1992 statute that prohibited states from authorizing or licensing sports gambling schemes, or, if they were authorized, from operating such schemes. New Jersey's plea that PASPA violated the anti-commandeering principle did not persuade the en banc Third Circuit, but the Supreme Court proved more receptive to the state's argument. New Jersey won 7-2. That victory likely would have been hollow had the court found PASPA's offending provisions on states authorizing or licensing sports gambling severable. PASPA's remaining unchallenged provision prohibited states and private parties alike from actually operating sports gambling schemes in the event that a state sought formally to authorize or license them. But over my dissent, joined by Justice Sotomayor, and in relevant part by Justice Breyer, the court held that had Congress known that it could not prohibit states from authorizing or licensing sports gambling schemes, it would have preferred no statute at all to one banning only operation of sports gambling. In my view, Congress would have preferred to salvage rather than wreck the statute, so the federal ban on operating sports gambling schemes, in my judgment, should have survived. But for anyone inclined to make a trip to New Jersey this summer, Justice Sotomayor's money is on the Yankees to win the pennant. A case coming to us from the Second Circuit, Jesna v. Arab Bank, presented the question whether the Alien Tort Statute permitted suit against a corporate defendant. The Alien Tort Statute was a product of the very first Congress, a 1789 statute that authorizes foreign citizens to sue in U.S. courts for torts committed in violation of the law of nations. The law of nations was the expression used in 1789 to mean what we today call international law. The petitioners were foreign nationals who brought claims against the Arab Bank, contending that the bank had knowingly financed terrorist organizations. The plaintiffs' petitioners sought damages for injuries caused by those organizations' attacks in Israel. Arab Bank argued that it was not a proper defendant. With many friends of court filing on its side, Arab Bank urged that the Alien Tort Statute applies only to natural persons, not corporations. The district court had entered judgment on the pleading for Arab Bank, agreeing that corporations are not amenable to suit under the Alien Tort Statute. A Second Circuit panel affirmed. The Supreme Court also agreed that the statute covers only individuals, not corporations, and therefore affirmed the Second Circuit's judgment. Justice Sotomayor dissented, joined by Justice Breyer, Justice Kagan, and me. In recent years, the court has confronted a number of questions concerning the impact of technology. The term just ended was no exception. I already mentioned the Microsoft case concerning government access to emails stored abroad. Another case garnering considerable interest, Carpenter against the United States, at issue, whether the government's acquisition of a person's historical cell phone location information from a third-party service provider qualified as a Fourth Amendment search, and if so, whether the government had to obtain a warrant to gain access to the information. The government argued that a cell phone user voluntarily shares her whereabouts with her carrier, so no warrant was needed to gain the information. In a 5-4 opinion written by the Chief Justice, the court rejected that argument, ruling that law enforcement generally must get a warrant to obtain cell phone location information. Generating 5 opinions spanning 115 pages in the U.S. reports, the case has given Fourth Amendment scholars much to discuss in the weeks and years to come. Also involving the impact of modern means of communication, South Dakota against Wayfair. South Dakota, like many states, taxes retail sales of goods and services in the state. South Dakota requires retailers making in-state sales to collect tax at the time of purchase and remit the proceeds to the state's revenue offices. But under the Supreme Court's 1967 decision in a case called National Bellis Hess v. Department of Revenue of Illinois, and reaffirmed in a 1992 decision, Quill Corporation against North Dakota, states were not permitted to impose sales tax collection obligations on out-of-state retailers that lacked any physical presence in the state. As a result, states like South Dakota lost considerable revenue from the proliferation of internet sales made by out-of-state vendors. Emphasizing changes in the national economy since we last considered the issue, South Dakota asked the court to overrule Bellis Hess and Quill. And in a 5-4 decision by Justice Kennedy, the court obliged. The Constitution, we held, does not prevent a state from imposing a sales tax collection obligation on a seller merely because the seller lacks any physical presence in the state. With the internet, you can have the showroom right in your living room or bedroom at your fingertips. The Chief Justice, joined by Justices Breyer, Sotomayor, and Kagan, dissented, but they agreed that the precedent was wrong. Nonetheless, they thought the court should adhere to it on stare decisis grounds. That is, precedent, once decided, shouldn't be disturbed. The Federal Arbitration Act, no stranger to the court in recent years, was before us again in 3 consolidated cases. I will refer to them by the lead case, Epic Systems. The operative facts in each case were essentially the same. A group of employees joined in a lawsuit against their employer for alleged violation of federal and state laws requiring extra compensation for overtime hours. The employer moved to dismiss the suit, invoking a clause in the employment contract that denied the right to sue in court and required one-on-one arbitration of grievances, disallowing proceedings in which several employees joined together. And if any of you have credit cards, I'll bet that there is an agreement you have made, even though you didn't read the fine print, that you will not sue in court, you will sue only in arbitration, and you will not join with other people. But there's something different about arbitration of worker-related problems. And the difference is the National Labor Relations Act. That landmark legislation safeguards to employees the right to act in concert to improve working conditions. In a 5-4 opinion authored by Justice Gorsuch, the court sided with the employers, holding that the Federal Arbitration Act required courts to enforce the one-on-one arbitration clauses. I dissented, joined by Justices Breyer, Sotomayor, and Kagan. The court's decision, I explained, would lead to startling under-enforcement of statutes like the Fair Labor Standards Act, legislation designed to advance the well-being of vulnerable workers, and you can see why. The single worker who has a claim for overtime pay, well, it might not even be worthwhile bringing the arbitration because the costs would exceed the overtime compensation due. But if you can join together with dozens, hundreds of similarly situated workers, then it is worth litigating the matter. Another closely watched case in the labor area, Janus against American Federation of State, County, and Municipal Employees. The petitioner in that case asked the court to overrule a 1977 decision, Abood against Detroit Board of Education, and hold that requiring public sector employees to pay anything to a union violates the First Amendment. The court's decision in Abood had required all workers, including those who did not join the union that served as exclusive collective bargaining agent, to contribute to the cost of collective bargaining and union-operated grievance procedures on the theory that that benefited all workers, union members or not, but relieved the people who opposed the union of any obligation to support the union's political activities. That decision had survived a similar challenge 2 terms ago in Fredericks against California Teachers Association, but the handwriting was on the wall because the 8-member court divided 4-4. With the court back to full strength in the 2017 to 2018 term, Abood was once again up for reconsideration, and in a 5-4 decision by Justice Alito, announced on the very last day of the court's term, the court overruled Abood, requiring public sector employees to pay anything to a union the majority held, violates the First Amendment by compelling employees to subsidize private speech, that is, the union speech, on matters of substantial public concern. In a forceful dissent joined by Justice Breyer, Justice Sotomayor, and me, Justice Kagan explained that the Abood decision, the 1977 decision, had struck a stable balance between public employees' First Amendment rights and government entities' interest in running their workforces as they thought proper. The court's decision, Justice Kagan warned, will have large-scale consequences affecting thousands of contracts involving millions of public sector employees. One fear is, if you can get it for free, if you're a non-union member, why continue to pay union dues? You'll get the same services anyway. Another case in which the challengers invoked the First Amendment, in National Institute of Family and Life Advocates, a group of crisis pregnancy centers challenged a California law requiring centers with a medical license to display a notice informing patients that California provides financial assistance for reproductive and maternal health, including contraception and abortion services. The law also required unlicensed centers to notify patients that they are unlicensed. The District Court of Ninth Circuit rejected the Pregnancy Crisis Center's First Amendment challenge. Justice Thomas, writing for a 5-justice majority, reversed. The disclosures, he said, impermissibly compelled the center's speech. The centers opposed abortion and therefore should not be compelled to advertise its availability. Justice Breyer wrote a dissenting opinion in which Justice Sotomayor, Kagan, and I joined. Justice Breyer pointed to a prior case that upheld a law requiring doctors who perform abortions to tell their patients about adoption services. Sauce for the goose must serve the gander as well, Justice Breyer maintained. Several cases this term concerned election law. Perhaps topping the interest list was Gill against Whitford, a partisan gerrymandering challenge to Wisconsin's state assembly map. A 3-judge federal district court enjoined the plan, concluding that its drafters had rigged it to favor Republican candidates in violation of the First Amendment and the Equal Protection Clause. In an opinion by the Chief Justice, the court unanimously concluded that the plaintiff's claim failed at the threshold as they had not shown Article III standing to sue. To qualify as plaintiffs, the court held, the plaintiffs must show that they, in fact, resided in the gerrymandered districts. 7 justices voted to vacate the decision below and remand for the plaintiffs to try again. Should not be too hard to find willing plaintiffs in each of the gerrymandered districts. Justice Thomas, joined by Justice Gorsuch, agreed that the plaintiffs lacked standing, but would have remanded the case with instructions to dismiss the complaint. Justice Kagan wrote a concurring opinion that reads as a blueprint for a complaint that could be successful. Justice Breyer, Justice Sotomayor, and I joined her. One more case of huge national and international interest, a challenge to the president's policy restricting the entry into the United 'United States' of various nationals, an order colloquially known as the travel ban. That ban had been subject to various twists and turns during the term. We were set to hear argument on the second iteration of the ban in October 2017, but that version of the ban expired 2 weeks before the argument, so the case was removed from the October calendar. The second iteration of the ban was replaced by a third, a more permanent version, a presidential proclamation. The Ninth Circuit affirmed a preliminary injunction, generally barring enforcement of the proclamation's entry restrictions on statutory grounds. The government sought review, which we granted, and on the very last day this term, the case was finally heard, the last argument day. In a 5-4 decision, Trump against Hawaii, the court reversed the preliminary injunction. Writing for the majority, the Chief Justice held that the ban did not exceed the scope of the executive's authority under the Immigration and Nationality Act. On its face, the Chief Justice said there was no infirmity in the proclamation. And the court's opinion also rejected the plaintiff's Establishment Clause challenge. But notably, the court took the opportunity to repudiate a 1944 decision, Korematsu against the United States, a decision that had upheld the internment of Japanese Americans during World War II. Korematsu, the court wrote, was gravely wrong the day it was decided. Justice Breyer, joined by Justice Kagan, dissented in the travel ban case, contending that the lawfulness of the ban was bound up with how the government was applying the proclamation's elaborate system of exemptions and waivers. In Justice Breyer's view, more information was needed on that front. But in the absence of that information, Justice Breyer and Justice Kagan found the evidence of an anti-Muslim bias a sufficient basis to affirm the injunction. Justice Sotomayor, who I joined, wrote a less temperate dissent. We would have held that the proclamation violates the Establishment Clause because a reasonable observer would surely understand that the proclamation, given its genesis, was motivated by anti-Muslim animus. While the court labored to complete last term's work, we also began to fill our docket for the upcoming term. So far, we have granted review in 38 cases, putting us well ahead of the 26 cases we had granted by the end of the October 2016 term. The 2017 term was weighty, I think you would agree, but it had some lighter moments. During the argument in District of Columbia v. Wesby, a case about whether police officers had probable cause to arrest some particularly enthusiastic partygoers, Justice Kagan became nostalgic. In the course of discussing the perspective of the reasonable partygoer, Justice Kagan noted that once, long ago, she used to be invited to parties with hosts whom she did not personally know, and that long, long ago, marijuana maybe was present at those parties. Another lighthearted moment at oral argument this term in the airing of the Microsoft case, the one I mentioned earlier, Justice Kennedy asked if a person in Ireland is involved in the retrieval of emails stored there. No, counsel responded. A robot performs all the tasks. Justice Sotomayor commenting that her imagination was running wild, wanted more information. Who tells the robot what to do? And exactly what does the robot do? She asked. A listener could be forgiven for wondering if she were observing a Supreme Court argument or the latest episode of the television show Westworld. Two advocate-related items of note. In city of Hays, Kansas, against Voight, a case about whether the Fifth Amendment is violated when compelled statements are introduced at a probable cause hearing. I was treated to a superb argument by especially familiar faces. All three advocates, counsel for the city, counsel for the individual opposing the city, and the assistant to the Solicitor General, had served as my law clerks. The case ended on a low note. It was dismissed as improvidently granted. A less familiar face also appeared before our court last term, that of Deputy Attorney General Rod Rosenstein. Reviving a Justice Department tradition, the Deputy AG donned a formal morning coat and argued for the government in Chavez Meza v. United States, a case about a district court judge's obligation to explain certain resentencing decisions. Deputy AG Rosenstein can now claim a perfect 1-0 winning streak in cases argued before the court. With Justice Gorsuch recused, the court ruled 5-3 in favor of the government's position. As a young attorney, the Chief Justice quipped that only Supreme Court justices and school children take the summer off. After a term of challenging cases and issues and an unusually high number of 5-4 divisions, as I see it, we earned our summer break, which enables me to be here with you this evening. Thank you for being such a patient audience.
Well, thank you for those observations, Justice. I wonder if either you or any of your colleagues were inclined to ask Deputy AG Rosenstein whether his argument was the easiest day he's had since the beginning of his tenure. Felt like a day off for him, maybe. So when I give U.S. Supreme Court updates, as I do at the end of every term, I try and capture the term in some way before digging into the details like you just did. Is there a way you would generally capture the term that just ended?
Much more divisive than is usual. I hope next term we will get back to our usual 15% sharp division rather than nearly 40%.
And so an uncommonly divisive Supreme Court term, you would say?
Yes.
Yeah. It struck me as a term in which, on more than one occasion, Justice Kennedy was looking for an off-ramp.
Was looking for?
An off-ramp.
Yeah.
So you mentioned how few were the questions that he asked. I think most obviously is Gill against Whitford, in which back when I clerked for you in 2003, 2004, we had Veith against Jubilier, and Justice Kennedy held out the opportunity if scholars or advocates could come up with a judicially administrable doctrinal test for partisan gerrymandering. Maybe just then the court would allow such claims, and it seemed like the issue was teed up this term. And then you had the standing holding that you just mentioned. Another case that struck me as similar is Masterpiece Cake Shop, because that was a case in which it was widely expected that the court would offer critical guidance about how to adjudicate conflicts between the anti-discrimination values protected by public accommodations laws on the one hand and the First Amendment's free speech clause on the other. And it struck me, at least, as more than a bit of a stretch to find a free exercise violation to avoid saying anything about the question on which the court granted.
But there will be another opportunity. After the Masterpiece Cake Shop case came down, we remanded another case, the case of a florist who refused to supply flowers for same-sex wedding. That case doesn't have anything like what was present in the Colorado case. That is, the suspicion that the two of the commissioners on the Colorado Commission were hostile to religion. There's none of that in the florist case. So we will see. And now it's back in, I think, the state of Washington Supreme Court, and we will have another opportunity.
Yeah, no, there's no doubt that there'll be an opportunity with respect to both of those questions. Right? It's also clear now, as you mentioned, that the court will be differently constituted when those issues arise. Right? That Justice Kennedy will not be participating in their resolution. Do you have a decision you would point out as the court's best performance this past term? The most important case in which you think the court got it right?
The Carpenter case.
Carpenter?
That the chief wrote the opinion, and this is the cell phone location case, where you can be placed within a very specific area, used in this case, to catch someone who had robbed a store, and he was located in the vicinity of that store several times prior to the robbery. So I think that was an important case. It doesn't say that the law enforcement can't get at such location information. It just says they have to go before a magistrate and show probable cause.
What about the court's worst performance in your view? The case in which you were in dissent, in which you most would have liked to have been in the majority?
Oh, it'd be hard to say.
If you have to pick two, that's fine. But.
Well, I wrote the dissent in the Epic case, the one that says employees can bring their disputes with their employer only before an arbitrator rather than a court, and only one at a time. And the arbitration decision, even if they would prevail, doesn't count as precedent. I think that was, as I said in my opinion, quite contrary to the National Labor Relations Act.
Mm-hmm. Could I ask you a question about the Murphy case in which you dissented? So, and you spoke about this. You focused on severability,
yes.
but you dissented in full, not in part, and you
yes.
didn't address whether what Congress had done was commandeering, and if so, whether the anti-commandeering principle. The anti-commandeering principle is a principle the court articulated in 1992. The court held that it's impermissible commandeering for Congress to require states to enact, administer, or enforce a federal regulatory program.
I think it was a gun. The federal law enlisted local sheriffs.
That was 97 in Prince.
Yes,
yeah.
that was Prince.
New York was 92,
yes,
the
right.
disposal of radioactive waste. Right. But you didn't explain in Murphy, did you think this was commandeering, and if so, did it matter? In other words, it appears at least that Justices Breyer and Kagan endorsed the anti-commandeering principle, and it wasn't clear to me from your dissent.
And it was unspoken, but I relied on the position that I took in the Prince case.
Right, which rejects the anti-commandeering principle. Okay, that makes
But
sense.
I thought that this was a simple case. There was a clear answer. If you can, the federal law was no operation of sports gambling, and it seemed to me that it was eminently severable from the licensing and authorizing.
All right, let me switch gears and I have more questions about the term, but for another time. How has the court changed over the quarter century that you've served on it? How is it different than when you started?
Well, one thing that isn't different is the collegiality of the court, and that remains. Of course, I miss my favorite sparring partner, Justice Scalia. But you don't see that kind of friendship existing in our Congress anymore. It once did. I hope it will again. If you might recall, Neil, that when I was nominated by President Clinton, the vote was 96-3. It's not that way anymore.
Yeah. And Justice Scalia, I believe, was unanimous.
Yes, he was unanimous.
Yeah. Do you think the court its relationship to its own precedents has changed? Do you think the court is more or less or about the same in terms of its sensitivity to personnel changes?
To personnel changes,
Yeah.
All the outward manifestations are as they have been. One is that the retiring junior justice, the person who has served as junior justice and has been replaced, gives a dinner in honor of the new member of the court. The chief still buys some wine, and we have a happy birthday chorus for every justice's birthday. We still have our delightful musicals twice a year. But of course, with every change in personnel, it's a new court.
But it sounds like the court is no less collegial than it was when you first joined it.
Yes, that's.
How is Justice Gorsuch different from your dearly departed friend Justice Scalia? We've heard a lot about their similarities jurisprudentially, methodologically. How are they different?
Justice Gorsuch was a law clerk when I first met him. When I came on board, Justice Gorsuch had been engaged by Justice White as Justice White's clerk. Mm-hmm. So when Justice White stepped down, Justice White generously gave his law clerk to Justice Kennedy, and that's how Justice Gorsuch ended up clerking for Justice Kennedy. But I can remember him from the days when he was very young. And there is no one on the court that was a match for Justice Scalia's sense of humor.
Is the court, are there non-obvious ways in which the court is different without him? Without Justice Scalia?
Well, his spicy opinions are no longer.
That's why I said non-obvious.
Yes.
Yeah. Do you, or as far as you can tell your colleagues, I'm just listening to you go through the opinions from the term, and the number of cases that people are paying the most attention to, in which you have the 5 nominees of Republican presidents lined up against the 4 nominees of Democratic presidents. Is the court a more polarized, even partisan institution than it once was?
Well,
do you worry that it appears that way?
Carpenter was the exception. In every case this term where the court divided 5-4, Justice Kennedy was with the 5. But the Chief's opinion in Carpenter, I think, was a very fine one. obviously I think that because I joined it.
Yeah, no, that's...
And another case that didn't divide on party lines was the sales tax case.
Wayfair.
Yes.
Yeah. Yeah. The reason I ask is because I worry. I worry that, at least in terms of public perception, which is a powerful source of the court's legitimacy, that the court is, the more it splits in these kinds of predictable 5-4 RD ways, the more the political scientists are shown to be true when the law professors tell them you actually have to read the opinions. And they say we don't have to tell you what the outcome's going to be. Not in many of the cases, but in the ones that people care about most. Right? The more that keeps happening, right? The court's legitimacy, the court's reputation suffers. And
well, all the returns aren't in. This was one term, and it did have a more than usual number of high-profile cases. Mm-hmm. You will remember the old chief. I could count on then Justice Rehnquist dissenting from every case in which I prevailed except the Weisenfeld case, which even he couldn't resist. But toward the end of the term, think of his tenure on the court. Think of Miranda. I don't know how many times Justice and then Chief Justice Rehnquist had criticized Miranda and saying the justices made it up, it's not in the Constitution. Then we were confronted with a case that asked us to overrule Miranda. The chief assigned the opinion to himself, and he said, we will not overrule Miranda. It has become part of the culture, and it's working. The old chief also wrote the decision upholding the Family Medical and Leave Act. I brought that opinion home to my husband, and his comment was, Ruth, did you write that? Mm-hmm. So as long as one lives, one can learn.
So you're holding out the possibility that, right, justices who are there, say 2 decades from now, may have different views on important issues than they currently articulate.
Yes, at least 1 or 2.
At least 1 or 2 justices, or 1 or 2 views? All right. Well, that's the beauty. I ask the questions, and she decides whether she's going to answer them. All right. So those were heavy questions, and now I'll turn to lighter matters, and I'll begin with a question that I am often asked by people who know of my connection to you. Right. So, Justice Ginsburg, how are you feeling?
I met my personal trainer yesterday. Mm-hmm. We will have another session tomorrow.
Have you seen any good documentaries lately? I was watching one recently that reminded me of you.
But that shows part of the routine. There is another segment in the Steve Colbert show. Mm-hmm. Yeah. Mm-hmm. We were going through the routine side by side, and I looked down and saw he was doing his push-ups on his knees.
Yeah. I won't touch that. What's your favorite part of the documentary?
My granddaughter, my conversation with my granddaughter.
Do you know what? Do you have any guesses on what my favorite part of the documentary is?
What?
you watching Kate McKinnon act not at all like you, and watching you laugh, and then you're asked a question that my own daughter has asked me, which is, are you at all like that? Right? And you said, no, not at all. So I thought that was hilarious. I also thought the documentary, it did a lot of things very well, but I think capturing your relationship with Marty and how much love there was from beginning to end, and how much he supported you and in very real ways made possible the career that you've been able to enjoy.
That's also captured in a new film that will come out on Christmas Day, called On the Basis of Sex. The screenplay was written by my nephew, the youngest son of my husband's sister.
What do you make of your cultural celebrity?
It's absolutely amazing. I'm 85 years old and everyone wants to take a picture with me.
I want to hear more, right? Because
the best story about my celebrity status goes back some years. It was the year of Bush v. Gore. And Marty and I were in New York. We went to the theater, and at intermission, everyone stands up and applauds as I come down the aisle. And Marty whispers to me in not such a hushed tone, "Oh, I forgot to tell you, there's a tax lawyers convention in town."
That's right. Yeah. That's right. Look at all the people who came to see me tonight.
So I missed that.
Do you think there's I look for meaning in things, and you and what you stand for, and that it's happening, say, over the past, beyond putting Bush versus Gore aside, the last 5-10 years, right? I mean, I think it says something about you, but it also says something about the culture and the constitutional culture that you would be so recognizable by people who don't follow the Supreme Court.
There are some efforts to promote understanding of our government, how it works, and one of them is Justice O'Connor's iCivics project, which has been very successful. It's been adopted in grade schools across the country.
Do you think civics is less emphasized than it used to be and less emphasized than it ought to be?
It's less emphasized than it once was. And that's why Justice O'Connor began the iCivics program.
I was thinking about your comments a little while ago about the kind of friendship that you had with Justice Scalia, and there used to be such friendships in Congress, but not so much anymore. And I wonder if you, if you start when people are young, right? And the civics education project is a nation-building project. There has to be ways. I don't think things will get better on their own, right? There has to be a way to bridge the divides that have gotten substantially worse over the course of your time on the court. And perhaps civic education is one way to do that.
And another way, this has been done in a number of high schools, is to have moot courts, to take a current Supreme Court case, perhaps simplify it, and give the students an opportunity to argue both sides of it. Because I think it's true that you can't be an effective dissenter unless you really understand the other side's argument.
Yeah, and you've made that point consistently, that Justice Scalia made you better, made your opinions better.
I said if I could choose who would write the dissent to a majority opinion assigned to me, it would always be Scalia, because he pointed out every weak spot. He was very smart and very sharp. And then I had an opportunity to fix it up and make it a better opinion than it was when I first circulated it.
And what is your secret to never having taken his barbs personally?
I just knew him too well, and I said on many occasions, this is over the top. Mm-hmm. You should tone it. If you tone it down, you will be more persuasive. That was advice he never took. But that was just his style. And no one reading his VMI dissent would believe that he had come to my chambers and given me an unfinished draft. It wasn't ready to circulate to the court, but just to give me the additional days to answer it.
What did you learn from your parents?
Well, I learned from my mother the two things. One, be independent. That idea was, it would be great if you meet Prince Charming and live happily ever after, but be able to fend for yourself. That was one thing. And the other that has stood me in very good stead all my life. She summed it up as being a lady. Being a lady is someone who does not give way to emotions like anger, remorse, jealousy, because those emotions just sap your energy and detract you from doing the things that you should be doing.
So in attendance this evening are the students in the DC Summer Institute, and most of them are thinking about law school. Any advice for them as they chart their own path in life?
Well, even in the ancient days when law schools were totally Socratic, I loved my experience in law school. And I found the difference between college and law school. In college, I was passively taking notes, listening to a professor. But in law school, I was constantly engaged in the colloquy that was going on.
And what about in terms of a career? Looking back on a meaningful career?
Well, there are few people who know exactly what they want to do. Marty knew, even before he took a tax course, he knew he wanted to be a tax lawyer. And when I was going to law school, I wasn't sure what. I mean, I wanted to be a great civil libertarian, but you also have to have a job that pays.
So it's okay not to know?
So I didn't know what that would be. And then I had the fantastic good fortune of being alive and a lawyer when the women's movement revived in the United States. And I could help nudge along that social change.
Have you sorted out your plans for the next 5 years or so?
Well, I answered just last weekend that Justice Stevens had stepped down when he was 90. So if I aspire to that same tenure, I have 5 more years to go.
Well, if at the age of 90 you are looking for a teaching job, I can promise you that Duke Law School will give you very serious consideration. Last question, and and I think we'll leave it at this. How, right, you are not done. We're looking ahead, not just back, but at some point, right, like everyone, your time on the court will be over. How do you most want to be remembered?
As someone who did the best she could with whatever talent she had to make things a little better for people less fortunate, to move society along a democratic path.
Well, Justice, thank you 6 times over for being with us, for making this possible, and I'm grateful to you, and on behalf of the entire Duke community, thank you. Thank you very much.
Thank you, and everyone, please be seated.